49 of the House of Commons Standing Committee on Justice and Human Rights, pursuant to Standing Order 108 Sub 2 and the motion adopted on January 30th, 2023. The committee is beginning its study on extradition law reform. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23rd, 2022. Members are attending in person in the room and remotely using the Zoom application. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. I will use some cue cards for those that are not familiar, and those are when you're closing in on your 30 seconds, I will raise the yellow card, and when you're out of time, the red card. So I'd ask that you try to complete your submissions or questions or answers within that time period so I don't have to interrupt you. Otherwise, I advise that you keep tabs of the clock on your own. For the first hour, we are concluding our witnesses' hearings on our study on extradition. We want to welcome Mr. as individuals, Anand Dubey via video conference, and I think we're working on one more. Yes. Did I hear something? No, sorry. We're working on one other panelist, and I think the Ms. Saint Laurent is just having some technical difficulties, so we may have to suspend if it's not corrected by the time Mr. Dubey finishes, but we'll see what happens at the time. So we'll begin with you, Mr. Dubey, for 5 minutes, your opening statements, and then we'll begin a round of questioning. Thank you.
Good afternoon, and thank you to the committee for inviting me to give evidence. I think that the questions which the committee is examining are drawing out some of the inherent tensions that exist within the extradition system, which is to ensure effective cooperation for prosecution and punishment of criminal offences, which has to be balanced against the need to protect civil liberties and human rights. The United Kingdom has grappled with these issues on a number of occasions, and in 2010, I was appointed as part of a panel to review the United Kingdom's extradition arrangements. When we were undertaking this task, we were very aware that we had to take into account the potentially serious consequences for a person who may be sent to face trial in an unfair legal system, where they may in fact be dealing with a language they do not speak, with little or no support from family, friends, or their community. We also looked at the fact that we wanted to try and recognize the potential shortcomings of the extradition system itself and the requesting country, while not allowing this, except in an extreme situation, to become a complete bar to extradition. This can be made more difficult when decisions are made during the extradition process by politicians, because these are often interpreted by the requesting state as being diplomatic rather than judicial decisions, and they can lead to potential diplomatic repercussions. In today's world, with globalization and technological advances, it is increasingly common that more than one country may have jurisdiction to prosecute. This is leading to increasing public debate as to how the question of which country should prosecute is decided, and extradition cases can cause this issue to often come to the fore. I thought it might assist the committee if I explain very briefly a few of the changes which the UK has made to its extradition law to deal with specific problems which it has faced. In particular, there was an issue in relation to requests from other EU member states because they have what's called the principle of legality. And that means they will make a request for any extradition offence, no matter how minor it might be, because there is no discretion involved in deciding whether to make a request. That led the UK to be concerned that extradition was being granted for what may be seen to be relatively trivial offences, so it introduced a proportionality bar where the UK can now look at the seriousness of the conduct, the likely penalty that might be imposed, and whether there are less coercive measures which might be employed rather than extradition. A further issue which has arisen is in relation to the ability of the UK to evidence as part of the extradition process. For most countries, evidence is not required, either because they're EU member states or because they're parties to the European Convention on Extradition, or because they are trusted partners of the United Kingdom. So those include Australia, New Zealand, Canada, and the US. The UK therefore relies to a large extent on the court's ability to invoke its abuse of process jurisdiction to protect where there may be improprieties in relation to the extradition process itself. There is also a question about whether somebody who is a resident or national of the UK should be extradited to face prosecution in another country. As I said in my first remarks, I think actually what this goes to is a question of where somebody should be prosecuted, because very few people are suggesting there should be impunity, and simply because you are, for example, a UK national, you shouldn't be subject to prosecution if there is sufficient evidence to justify it. In the UK, they've introduced a forum bar, and this requires where there is a substantial misconduct that takes place in the UK, which means that the UK could prosecute. The court can then consider whether it's in the interest of justice for extradition to take place. And there are a specified number of factors which the court can take into account, but it can only take those factors into account. The court also consider human rights, and it must do so. So if there is a real risk of a violation of a human right, then this will lead the court to bar extradition. And one of the rights is Article 8, the European Convention on Human Rights, which relates to the private and family life. This can allow a court to consider, firstly, the effect on other people of extradition, so most particularly the effect on children of extradition of their parents, for example. And it can also allow the court to consider the effect on the requested person. So it has to carry out its own proportionality exercise. Now, ordinarily, obviously, the court finds that extradition is justified, given the need to prosecute serious crimes and the need to cooperate internationally, but it does allow flexibility for a court to take into account whether there are other reasons why it would be proportionate in a particular case. The other thing I'd just like to finish with is I've seen that one of the issues in Canada relates seemingly to the role of the prosecutor. So it's probably worth emphasizing that within the UK, whilst extradition cases are dealt with by the Prosecution Service, which is the UK's national prosecutor, they act as a Minister of Justice in extradition cases, and therefore they owe an obligation to act fairly. And they also have a specific obligation to disclose evidence they're aware of that might undermine or weaken the requests they're prosecuting if it's within their knowledge. So there is an overriding obligation of fairness, which they also have. So I hope it gives the committee some examples and ideas of how the UK has tried to deal with some of these issues, and I'd be very happy to answer any further questions.
Thank you, Mr. Dubé. We'll next go to Ms. St. Laurent, but we're going to ask you just to do some sound tests real quickly, just as you just came on, so that our interpreters can make sure. We'll ask you if you can put on your headset, Ms. St. Laurent, so that the sound will come clear. And I'll let the clerk take over and do some sound tests.
Bonjour, Madame Saint-Laurent, est-ce que vous nous entendez?
Hello, can you hear us, Madame Saint-Laurent?
Madame Saint-Laurent, ça va prendre.
Madame Saint-Laurent, you will need to put on your headset, please, before we can proceed.
Madame Saint-Laurent, vous pouvez mettre votre...
Madame Saint-Laurent, if you could please put on your headset and perhaps talk about the weather in your region so we can do a sound test. And please, you're on mute at the moment. Is that okay for the sound test? We'd need a bigger sample than that, please. So good afternoon, Mr. Lafleur. How are things for you? Fine. Could you speak for 15 seconds so we can have the sound test? Yes, I had a bit of an adventure. It took about half an hour to try and test all this, but finally I'm connecting with you. Can you hear me? Yes, that's okay. Thank you.
Thank you, Ms. St. Laurent. So you will have 5 minutes for your opening statements, and since you didn't see it, I'll put up a cue card when you are within 30 seconds, and then a red one when your time is out. So if you could stay within that time, that would be great. So over to you, Ms. St. Laurent.
Bon.
So I'll just take 30 seconds to put on my glasses because it was quite the adventure to connect with you. So good afternoon, Chair. Good afternoon to you and all the members of the committee. It's a real pleasure to be with you. And I'd like to invite you to read my submission, and I'm ready to answer all of your questions. I'd like to make the following important points. First of all, the current Extradition Act enables our Canadian citizens to be extradited on evidence of questionable veracity and reliability. Why? Because it's based on hearsay. All that we receive by way of evidence is an account of events by a second or third person. There are no sworn statements or solemn affirmations from witnesses. And when we talk about certification, then we're talking purely about personal affirmations, and even worse than that, the case law states that the extradition judge does not have to question whether the content of the record is true or not. Then secondly, we have had universal jurisdiction since 1999 to try Canadians who are alleged to have committed crimes abroad, for example, Rwandans and Canadians who were judged for having committed crimes in Mexico. They were all tried here. At the very least, we should allow our citizens to plead guilty in Canada, which is not contrary to our contractual obligations, and even more so if a Canadian citizen is suffering from a mental illness. And then fourthly, disproportionate sentences. For example, trafficking Xanax in Canada comes with a maximum of 3 years, whereas in the US it's a minimum of 5 years and a maximum of 40 years. And all of that's for exactly the same offence. I don't know if the 5 minutes is up because the rest of my remarks are in this submission. And I know that you have questions to put to me accordingly.
It's Ms. St. Laurent, so you have another 3 minutes if you'd like to go.
Non, de toute façon.
No, I know that with a brief, everyone can now put questions to me, and I'm ready to answer your questions, and I'll add some comments in then. Thank you.
Sounds good. Thank you. We'll begin our first round of questions for 6 minutes. Sorry, just to let everyone else know, I think we were not able to get a House of Commons approved headset to Mr. Herman, who was, I believe, traveling to Europe, so he will not be giving evidence at this point, so it'll be just these two witnesses. So our first round of questions will begin by Mr. Van Popta for 6 minutes.
Thank you, Mr. Chairman, and thank you to the witnesses for being here with us. Mr. Dubé, I'll start with you. Thank you for taking the time to meet with Canadian parliamentarians. We really do appreciate it, and the opportunity to mine your brain, to learn something about your experience in the EU. You talked about some of the tensions in the EU in the realm of extradition law, and we're feeling some of those same tensions here. I read somewhere that you had argued cases based on revealing the tension between a motive to seek justice and a motive for political motivation. And I wonder if you could comment on that. How do we distinguish between the two? And I'm thinking particularly of our Hassan Diab case. I don't know if you're familiar with it, but it was a case where a Canadian national was extradited to France based on pretty skimpy evidence. And we feel that it was probably more politically motivated than a motivation of justice. So what's your comment on that?
Votre question est très longue.
That's a very lengthy question.
No translation.
I meant the question for Mr. Dubé because he had commented on the tension between political motivation and motivation to seek justice. So, Mr. Dubé.
Before Mr. Dubé answers that, Ms. Saint Laurent, on your screen, there's a function called interpretation. If you click on the English or French, you'll get the interpretation in that. It's probably on floor for you right now. Mr. Clerk, I'll let you.
Should I go ahead and answer?
Retourne de... Bon.
Well, now I can't seem to get the interpretation in French, says the witness.
Si vous
Madame Saint Laurent, look at the bottom of your screen and you'll see that icon, participant, raise hand. And then there's interpretation next to that. Just click on interpretation. And then click on French after that. And you'll be able to get the interpretation.
Parfait.
Now, hopefully you'll hear me in French, Ms. Saint Laurent. So I trust the translation is going okay. Okay.
Perfect.
Mute yourself
Oui,
now, and
très
Mr.
bien.
Dubé, if you can begin answering that question. And I had stopped the clock, so I'm not taking any time out of Mr. Van Popta.
Thank you. So I think that we need to be clearer about political motivation in terms of the way I've used it in particular cases. So there are a number of ways in which to argue that a prosecution has been brought for an improper reason, because obviously prosecutions are supposed to be brought in order to simply prosecute crimes which are legitimately suspected. So in some cases, one can point to a purely political motivation. For example, it's an opposition politician, and the government is simply bringing a prosecution in order to silence that politician. In other cases, there can be a commercial motivation. So the government has its own commercial interests, trying to advance them by bringing a prosecution to support that. And in some cases, there may be a political interest in terms of prosecuting a particular case. So a government may feel public pressure to bring a prosecution because there is a crime which is particularly sensationalized within that country. In the UK, we have a number of different legal ways of dealing with the particular cases. So we can make arguments for human rights bars to say that if you're being prosecuted for a reason that's not proper, then it's a breach of particular articles of the European Convention. We can also make arguments under the abusive process jurisdiction I mentioned earlier. And finally, we can make arguments in relation to particular what we call extraneous grounds. So if you can prove that you're being prosecuted for your political opinion or your gender or your race or your nationality, then that also will operate as a bar. I obviously have read something about the case which was referred to in the question, but I'm not claiming to be familiar with it. But I think the difficulty with those types of cases can be that the government may have an interest in prosecuting a particular case because it's of great national importance, and it may do so with very little evidence to support its request. I think that would fall into a slightly different category in terms of what I have referred to as politically motivated requests, because where I'm using that term, I'm really meaning the government has its own political interest separate to simply prosecuting a crime, opposed to the government may be willing to overlook evidential difficulties in terms of trying to bring somebody to be prosecuted. We've had those cases in the UK. So after the terrorist attacks in the US, there was a particular case called Locke v. Ricey, where the US tried to bring an extradition request. But actually, this was the case which gave rise to the principle I referred to, where the prosecutor was said to have to disclose material which undermined the US's case. That led to the US, in fact, not pursuing the extradition request.
Good. Okay, I have a question. My next question is about the burden of proof on the requesting state. We had witnesses here earlier in the study who said that the burden has shifted too far in favor of the requesting state and away from a sense of justice or human rights. But we had other lawyers that said, no, we have the balance correct. An extradition hearing is not a trial. The trial will happen in the other country. And so we parliamentarians are reviewing our law to see whether it should be amended, and we're looking for some advice from you on that.
Sorry, was that a question?
Yeah, so yeah, that is the question. Yeah, so how do we find the right balance between being efficient and cooperating with our extradition partners, and on the other hand, ensuring that human rights and justice goals are met?
Well, I think the difficulty is really sort of working out to what level you want to examine a case. I appreciate that there's obviously a slightly different system you have with the record of case, which we don't have in the UK. But as I explained earlier on, there are a large number of countries where they don't have to provide any evidence at all. All that's required is for them to make allegations. And as long as those allegations disclose criminal offences, then that's sufficient. And those countries include, for example, Azerbaijan, they include Turkey, they used to include the Russian Federation before it withdrew from the Council of Europe. So you can see that the UK doesn't apply any evidential test for a number of countries where there is certainly controversy as to whether that should be the case. I think that the argument that you're referring to as to whether the extradition process should be a trial is a difficult one, because obviously it is not possible to have a full trial applying the laws of the requesting state when you're dealing with an extradition case. There are cases where it seems to me that it is appropriate to examine further the evidence that's put forward. And again, within the UK, we tend to be able to do this by having the sort of safeguards of the human rights standards, where you could use those to try and say in an exceptional case, there is a reason to examine the evidence in more detail than ordinarily, and this residual jurisdiction of abusive process. So I completely understand that there is a tension and that it is not possible in every case to insist upon a trial when you're having an extradition hearing. But I do think that the system should cater for those exceptional cases where there is really something to be discussed in relation to the evidential test, and there's a potential for unfairness. And this particularly arises in relation to a specific aspect of the case you mentioned, because we've had this as well with cases where people have been extradited and then placed into pre-trial detention for long periods of time because their case has in fact not been ready to be prosecuted. So the UK introduced a bar which said if the case is not ready, has not been charged and is not ready to be tried, then that is a reason to stop extradition. And that was to cater for situations within the EU where there are long periods of pre-trial detention. There were lots of requests being made where people end up for many, many years in pre-trial detention.
Thank you, Mr. Dubé. Thank you, Mr. Popta. Next, we go to Ms. Dillon for 6 minutes.
Thank you to our witnesses for being here. I'm going to start with Mr. Dubé. Last week, during our last meeting, we spoke about the experience of racialized Canadians when it comes to the Extradition Act. Could you please comment a little bit about this?
Sorry, I didn't hear that session. So could you just explain by what you mean by the experience of racialized Canadians?
Yes, thank you. So racialized Canadian, as in Canadians who come from people of color or the LGBTQ community, etc., minority communities. Can you talk about the experience with them regarding the Extradition Act?
Yeah, so there is a specific set of bars which can apply if you can show that people are being discriminated against for those reasons, or well, the bar applies if you can show they're being prosecuted for that particular reason, or that they might face some form of prejudice after they're extradited. So that gives a pretty good protection. You just have to be able to prove a causal link. So you have to be able to show it's one of the reasons why they're being prosecuted, not the only reason, And you have to be able to show it's one of the reasons they may suffer prejudice after their return. And that prejudice can take a number of different forms. So, for example, you might be able to show that they would face harsher treatment in custody, or that they would be at greater risk of interpersonal violence. So there are all sorts of ways in which you can seek to show that there may be discriminatory treatment of them because of one of those types of characteristics.
Thank you for that clarification. And can you comment on the legal procedures of extradition, especially when it comes to the prohibition against surrendering a person to a country where it's likely they would be at risk of being tortured?
So that's something which we struggle with in the UK, because we have an absolute prohibition in relation to surrendering to torture ourselves. But in terms of when we're looking at extradition, we're looking at something prospectively. So the test is whether there is a real risk, evidence of a real risk of a violation of Article 3, which is the prohibition against torture. And the difficulty we now have is, I think, one that you were also agreeing with, which is that when that risk is now raised, if it is shown to be real, then a diplomatic assurance can be given in response to it, to say, well, whilst we recognize there's a real risk of torture, we guarantee that in this particular case, this person will not be tortured. Now, I have quite a lot of difficulties with this, because the only reason you need a diplomatic assurance is if there is a real risk. So you're then trusting a country where you've already established that there is a real risk they're going to torture somebody, to give you an assurance where they say, but you can trust us in this instance that we won't torture them. And there are particular difficulties as well with monitoring. So very often there is no monitoring mechanism which is built in, or the monitoring which a court suggests is going to happen is pretty fanciful. If, for example, they say, well, your client can complain if they are tortured, and you say, well, I'm pretty sure they're not going to want to do that when they're in prison in this country, because they're obviously going to face further ill treatment were to complain. So the methods which are suggested by the courts in the UK as sufficient to ensure there will be no ill treatment are, in my mind, not sufficient. And I think one of the things which one has to grapple with when using diplomatic assurances is how can you make sure that they are going to be effective in practice and that they're going to be monitored, given that they're only given when there is already an agreed risk of this bad treatment happening.
Thank you for that. And when it comes to monitoring, as you just mentioned in your response, what can governments do to better monitor or make sure that promises are being kept?
So in some instances, consular officials have been delegated to do this. But the difficulty is if it's not a national, so if it's not a British national, then the British consular officials don't have any right to see the person. But of course, the country can agree to it. But that gives resource implications where countries can be concerned about using consular staff in order to do this. But that, to my mind, is quite a safe way of doing it, because it gives the person a confidential ability to report ill treatment. The other mechanisms which have been suggested are human rights bodies, but again, there are just practical difficulties with. But I think the most serious issue about monitoring is, what do you do if there is a breach? Because the only repercussion is diplomatic, because the assurance which is given is diplomatic assurance. So it's given from one country to another. So even if there is a breach, and you can establish that in a way that's objectively verifiable, what then happens?
Thank you. And what kind of crimes are most often seen as part of extradition cases? What are the most common ones?
I'm not sure the UK is a very good example, because we now have this system with the EU, which allows for extradition requests from EU member states. And because they have this principle of legality, they don't exercise any discretion. So for most countries where this principle doesn't exist, there is a decision taken as to whether an offence is serious enough to justify the resources needed in order to make an extradition request. But within the EU, that doesn't really apply. So we face requests which are, range from what you would see as very serious to those which some people would consider to be much trivial. But I would just add one caveat, which is that it is quite hard to categorize seriousness unless you understand the context where these crimes are being prosecuted, because what may seem trivial to you in the particular country can be an endemic problem. So if there's a low standard of living, a theft of a chicken can actually be a relatively serious offense, even though in a different country that may seem pretty trivial.
Thank you, Ms. Dillon, and thank you, Mr. Dubé. Mr. Fortin, Monsieur Fortin, 6 minutes.
Merci.
Thank you, Chair. And thank you to the two witnesses for being with us, Mr. Dubé and Ms. Saint-Laurent. Ms. Saint-Laurent, I've got some questions for you first. I understand that you're a lawyer and you're in front of us today because probably you've certain experience when it comes to enforcing the Extradition Act. And I'm coming back to what you said in your brief introduction, where you said that Canadian citizens should perhaps be able to plead guilty here when they're guilty. And then there's a problem of these records where there's no sworn statements. Does this apply to one or several cases that you've worked on in your legal practice? You'll need to switch on your mic, Ms. Saint-Laurent. So here I am. No, when I was talking about pleading guilty, it's very important because it can be envisaged in certain cases, in particular if we have a client who's suffering, for example, from a medical condition or autism or Asperger's. It's a real difficulty for them to come to Canada without their family, the question of language. So that's a very important consideration. And it's difficult for these people to then adapt to going to the US, for example, and perhaps to be in prison for decades. And I was an expert to witness on one of these cases. There's a danger that these people would commit suicide. I think it's a cruel treatment with these particular cases. And then if you look at Cotroni, he asked to be judged in Canada, and the Supreme Court refused that by talking about the cost of bringing in witnesses, etc. But when we look at the disproportionality of sentences between the US and Canada, why can a Canadian citizen not actually plead guilty here in Canada? I don't think that would be working against our international collaboration. And I put that in my brief. The cost would be minimal for Canada and the US. And there would still be collaboration. In particular, now that we have universal jurisdiction that applies, I think that would be really advantageous. It's very, very important. I was really shocked that we were not able to do this. I really think that has to be rendered legal. I have not seen the decision, but I saw in a Cotroni, I think I just saw one decision, in fact, where the Supreme Court, because it went right up to the Supreme Court, this case, and this person said, I want to plead guilty in Canada. I can't remember the exact decision. I wasn't able to look it up because I haven't had much time to prepare for this because, as you know, I'm very busy. But why can we not plead guilty in Canada? The Supreme Court has said no. There has to be, for example, cooperation with the US, and the minister could decide on that. But I don't know whether there was universal jurisdiction that applied. I don't know the date of that ruling, but it certainly would be an advantage for people who are autistic or have a mental illness. I think we should allow that in all cases. I don't want to repeat what I've said. It's this question of disproportionality of sentences between the US and Canada. Madame Saint-Laurent, when you talk about the problem of these records, that there's unsworn statements and the judge has to judge these as complete and doesn't look at the validity of the evidence. You've talked about that. Is it because you have specific cases that you'd like to explain to us? Yes, I've got one specific case, but that's always the way. That's generally what happens. There doesn't need to be much evidence. It's like a preliminary investigation, but in fact, it's not like a preliminary investigation. Well, if you'd like to talk to us about your case, because we've just got about 1 minute left, so perhaps you could talk about your specific case now. Yes, I'll try and speak very quickly. It's extremely important. We ask for disclosure of evidence. We've got certain facts, but there's been no sworn-in witnesses. These are relative facts. And as it says in the Extradition Act, this does not need to be verified and so on. I had lots of suggestions to make. I thought I'd have an hour minus the 5 minutes, but it seems that I'm not able to go into these cases in detail after all. And that's a real pity. It's really regrettable because those were very important points that I wish to raise. You can certainly do that by sending in written notes, but unfortunately my time is up as well. Oh, well, I'm very happy to hear that. Thank you very much.
And as Mr. Fortin said, you're more than welcome to send your submissions in writing. So if you want to add more material, we'll be more than happy to receive that. Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and thank you to both the witnesses for being with us today. I want to go back to Mr. Dubé, who raised the question of what's called the forum bar. And I'd like to know a bit more about how the forum bar which in my understanding says if things can be prosecuted in Britain, there's a presumption that they will be prosecuted in the UK rather than extradition taking place. So did that come about through case law, Mr. Dubé, or was that legislated?
Came about through legislation rather than case law, but I think I just need to explain it a bit further because that's not quite what it does. So it says that if there's a substantial of conduct which took place in the UK, then the forum bar applies. So that's the gateway. And that generally means that it could be prosecuted in the UK because a substantial measure of the conduct has taken place there. And then there are a number of specified factors the court looks at, but there's no hierarchy to them. And so the court can give different weight to different factors. The factors include what prosecutions have taken place, whether there's an interest in prosecutions taking place in one country, the defendant's connections to the UK. So there are a variety of factors. One of them looks at the possibility of prosecuting in the UK. Now, a UK prosecutor can say there is no possibility of prosecution in the UK and can issue a certificate. And if they issue a certificate, you cannot invoke the forum bar. So that does give a prosecutor an ability to stop you from invoking. But that hasn't happened yet in any case in the UK. The prosecutor can also issue what's called a belief letter and say, look, I don't believe the most appropriate jurisdiction for prosecution is the UK, and they will then explain why they don't believe that. Now that happens in most cases, and the court will then take that into account. But the reason why the forum bar is difficult to operate is the defendant always has long-standing connection with the United Kingdom, and the court is trying to reconcile that with whether they can be prosecuted in the UK, which is happening, because if they were already being prosecuted in the United Kingdom, they couldn't be extradited. So you ordinarily have a defendant who's saying, well, I want to be prosecuted in the UK, where they're not being prosecuted in the UK, and the requesting country is saying, well, look, we're already prosecuting you. And we could do so quickly, and we can do so slowly. And for example, we have other defendants who are already prosecuting. So it's quite a difficult picture for a court to consider when weighing up these various factors. And often the court is put in a position where it feels like it has to order extradition, because if it doesn't do so, it may be concerned that the person is going to have impunity and isn't going to be prosecuted anywhere.
Thank you, Mr. Dubé. You also made reference in your original presentation to a proportionality bar. And could you talk a little bit more about how that operates and whether that came about legislatively or through case law?
That also came about legislatively, and it arose just because, as I say, there was a lot of public concern about the number of offences which were being sought from the EU member states, which were thought of as being trivial. So there are three limbs to the proportionality bar, and it only applies to requests made by EU member states. The first is the court looks at the seriousness of the offence, and there's a test laid down in terms of considering what's serious and what's not. It then looks at the likely sentence that's going to be imposed, and it then looks at whether there's a less coercive measure than extradition, which could achieve a just outcome in the case. And once it's looked at the combination of all three, it reaches an overall assessment as to whether it would be disproportionate to extradite in a particular case. And often what may happen is the person may be kept in custody whilst the extradition proceedings are ongoing. So, for example, the court may say, well, look, actually, the amount of time that you've spent in custody in the UK is probably about the same amount of time that you would have spent in custody if you'd been convicted of the offence. Or it may say, look, there's an offence which we don't think is significant enough to justify the extradition. And it will also try and test with the requesting whether there are less coercive measures. So whether the person could be sentenced to a non-custodial sentence or a fine or some diversionary measure, which would be short of a custodial sentence.
Sexual orientation, gender identity. Who makes that decision in the UK system? Is that a decision by a judge that would apply such a bar? Because in Canada, that's a decision that, of course, is left to the minister.
I'm so sorry, that's the first part of your question. Your audio wasn't working.
Okay, let's try again. And in the case of fearing persecution on the basis of factors like race, sexual orientation, gender identity, in the UK, who makes the decision? Is that a decision of the judge? Because in Canada, that's left to a decision of the minister on surrendering someone for extradition.
But that is a decision of the judge. And in fact, the minister in the UK has a very limited role now. They used to have a very broad discretion in the same way as I think you currently have in Canada. But over time, that has been narrowed down for the reasons I gave in my opening remarks. So the review I carried out recommended that the minister's discretion be narrowed even further, because at that point, the minister was still considering human rights issues, because we took the view that these were really judicial decisions and that they should be taken uninfluenced by political considerations, and they should be done in a transparent way. And in fact, the UK government agreed with that. So in the UK, the minister only now looks at, is there a risk of the death penalty? And if so, has an assurance been given that it won't be carried out? Are there specialty undertakings in place, i.e. has the country agreed the person's only going to be prosecuted for the offence they're being extradited for? And if there's an earlier extradition request from another country, how do you deal with competing requests? So the minister has a very limited set of questions to deal with, and they're very technical, essentially, in application. All the other issues are now dealt with by the courts.
Thank you. Thank you, Mr. Garrison. We'll go to our next round, which will be 5 minutes, and that's beginning with Mr. Brock.
Chair, I'd like to thank the witnesses for your attendance and participation. First question to you, Mr. Dubé. I listened very carefully to your opening remarks. You spoke about tensions in our current extradition system, punishment versus protection of civil liberties. Then you talked about the role of the prosecutor in Canada, and I'm not quite sure if I took down all of your notes, but you made reference to the minister of, or the prosecutor in the UK is akin to a minister of justice with duties of acting out with fairness and to disclose evidence that is not favorable. In other words, probably evidence that normally could be disclosed, but sometimes some countries may not disclose it. So my question to you is, were you trying to suggest that in Canada we do not have that type of minister of justice type of prosecutorial system when it comes to extradition hearings? Are you suggesting that our prosecutors deliberately withhold exculpatory evidence without that duty to disclose?
I'm certainly not an expert on Canadian law, so I'm not in a position to really comment on that. I've read some academic discussion which said that there is in Canadian case law a distinction between a prosecutor acting in a domestic criminal case and the role that they fulfill within an extradition process. But I think you'd have to address that question really to somebody who is a sort of Canadian expert on the extradition law. The only point I was making was that the UK case law is very clear that when the UK system, even though it is a domestic prosecutor bringing the case on behalf of a foreign government, they have a duty to act, and more specifically, they have a duty to disclose evidence which they know about, which might destroy or undermine the evidence on which the requesting state relies. So that duty overcomes their duty that they might owe as a lawyer to their client, because obviously in that situation they are essentially acting as a lawyer for the client, the requesting state.
You were specifically chosen by a member of this committee to provide evidence to aid this committee in reviewing our current extradition laws and provide a study to the government as to what recommendations, if any, should flow. So my question now to you is, did you, in terms of your preparation of today's appearance, did you do any thorough examination of Canada's current extradition laws with a view of perhaps suggesting ways that perhaps Canada has been contrasted to the system in the UK, or perhaps some suggestions on ways that we can improve our system to achieve that proper balance that most countries who do engage in extradition processes try to achieve?
It would do that, and that is why I've highlighted some of the issues I have done. Obviously, I've reviewed some of the commentary there has been about the existing system you have in Canada. Whilst I'm not an expert on Canadian extradition law, some of those issues have led me to highlight for you some of the reforms we have put forward in the United Kingdom, in case they are of assistance to you in dealing with the same issues you may be facing there.
Okay. One of the pieces of evidence that I've reviewed in advance of your testimony is a excerpt of a committee hearing on extradition that you participated in the UK House of Lords back in 2014. I appreciated it some time ago, but I think one of the questions put to you still has application today. And it was a question put to you by Lord Jones, and I'm going to read out his question to you, and then I may modify the question I ask of you afterwards. Lord Jones says, in the Baker Review, you wrote that extradition is a form of international cooperation in criminal matters based on comity intended to promote justice. Do you still subscribe to this view? And since you wrote that sentence, do you feel the government have focused too much on achieving efficient international cooperation on extradition and focused too little on ensuring the UK's extradition arrangements are just?
Very quickly.
So, thank you. Applying it in a Canadian context, sir, how would you respond?
As I say, I'm not a Canadian extradition lawyer, so from my assessment of the issues which I've seen raised in the context of Canadian extradition arrangements. The one that I think is common to Canada and the UK is this issue of diplomatic assurances, which I think are an issue that's going to cause difficulty for all countries trying to resolve the tension between a need to cooperate and to protect individuals.
Thank you. Thank you, Mr. Brock. Over to you, Ms. Briard.
Thank you, Mr. Chair. And I thank our two witnesses, Mr. Dubé and Madame Saint-Laurent, for being with us this afternoon. Mr. Dubé, I will ask you my questions in French. Do you have the translation? Est-ce que vous m'entendez bien?
Can you hear me well, sir? So during your preliminary opening comments, you asked us the question, where should we prosecute someone? I'd like to hear more about that, more of your thinking on that question.
So to my mind, that is the most important question, because I do not believe that anybody thinks that people should be allowed to get away with committing a crime and not be prosecuted for it. So for those cases where there is sufficient evidence to suggest that somebody should face trial, I think the most important question is, where should they face trial? In the UK, those decisions are generally taken between prosecutors of different countries, and it is certainly unclear to me to what extent they take account of the suspect or the defendant when making that decision. My concern is that ordinarily they only prioritize their desire to successfully prosecute somebody, or their desire to obtain the maximum penalty they can do when they prosecute. And what they don't take into account in the balancing process is the effect on the person of being taken out of the country where they live and where they reside and where they're familiar with the system, and being put into another country in order to be prosecuted there. And so for me, I think it is important that, as well as looking at the extradition process, you also look at the system for deciding where somebody should be prosecuted. Because as I say, in an extradition context, it is very unattractive for an extradition court to say, I'm going to stop extradition, but this person is not going to be prosecuted anywhere, even though there appears to be sufficient evidence to suggest they should be prosecuted. And referring back to one of the earlier comments, there are countries which do say that for their nationals or their citizens, they will refuse extradition, but they will prosecute them instead, so that they are not, rendered immune from prosecution, but they are then prosecuted in the country where they live or where they ordinarily reside, and in the system they're familiar with.
Merci beaucoup.
Thank you very much. That's very interesting. That leads to two sub-questions. In your response, you've said that we don't necessarily take into account the consequences of extradition. And earlier you talked about the impact on children, and we heard that with Ms. Diab last time, where she said that her husband was extradited and the children were stuck in Canada. So for several years, the family has not been reunited. So do you have other examples of that type of consequence that you could share with us?
So in the United Kingdom, there is a Supreme Court case which has established that the court in extradition cases has to take account of impacts of extradition on children. Now, obviously, there's always an impact. So the impact can't simply be that the child is deprived of the care of their parent, but it has to rise to a more severe level before the court will say it's sufficient to bar extradition. So, for example, it might be that there are no care arrangements which could be in place for children because both their parents are being extradited, and that would leave them with no one to care for them. Even then, the court now will look at whether there are alternative care arrangements that could be made by foster parents or other types of things. The other types of issues to do with children which can lead the courts to find it's not proportionate to extradite are medical conditions and mental health issues. So something that rises above the ordinary. I'm using that, advisedly, because obviously it's terrible for children to be separated from their parents, but the court has to be satisfied that there is something more than would normally be the case if a child is separated from their parent because they've been extradited.
They still have some time. So I've got 30 seconds. Earlier, You referred to torture and asking whether we should assess if there's a real risk of torture. Of course, it's difficult to assess that risk, isn't it?
I don't know if we have a sound challenge, Mr. Dubé, or if it's, I think the question was.
Sorry, I didn't hear the question.
Oh, so Ms. Briere, if you can repeat it real quick.
Okay.
Yes. Earlier, you said that we would need to know if there was a real risk of torture or not. And I wondered how you assess whether there is this real risk of torture.
Okay, so ordinarily, the court will look at NGO reports, country reports, US State Department reports to see whether there's a prevalence of torture which has been objectively verified. So you would have to establish a general pattern, and then you would normally have to identify how that could apply to your particular client. So you would have to show they fall into a category of people who are ordinarily subject to torture. So it's firstly a question of establishing general objective evidence and then applying it to of your client in terms of showing why they're also going to fall into one of those at-risk categories.
Thank you, Ms. Briere. We'll next go to our last round with for 2.5 minutes each, beginning with Monsieur Fortin.
Merci, Monsieur.
Thank you, Chair. I remain with you, Mr. Dubé, for my question. You've just answered Madame Briere, explaining how to proceed. I'd like to know whether that works. In your opinion, are we able to correctly assess the risk of torture in a foreign state?
I think it is difficult, but I think it should be difficult to prove that there is a risk of torture. The other thing we often use in the UK is an expert witness. So once you have the objective material in terms of showing that torture can be prevalent in particular countries and particular situations, in order to show it may apply to an individual, ordinarily what the court is assisted by is somebody who's an expert in that country who can say, well, look, I'm applying the generalities to this specific individual, and in my opinion, this individual is at risk of torture. So I think that, it's difficult to do, but I think the greater problem is the one I highlighted earlier, which is that now is routinely met by a diplomatic assurance saying, well, even if that risk exists, then there's no need to be concerned about it because we give you an assurance that it won't happen in this particular case.
Merci.
Thank you. I'd like to put another question to you, probably be the last question given that time is ticking. Could you explain the distinction that is made in the UK when we're talking about extraditing a UK citizen compared to a foreign citizen being extradited?
So there are two ways in which that can make a difference. The first is in relation to forum, because if you can pass through the gateway of a substantial measure of conduct happening in the UK, then one of the criteria which the court has to take into account is a person's connections to the United Kingdom. And obviously a UK national and resident is going to have stronger connections than somebody else who is not. The second way in which it can be relevant is Article 8, which is the right to private and family life. And that is part of a balancing exercise. And as I said, ordinarily, the court is going to find that the right to private and family life is outweighed by the need to have effective extradition arrangements. But in a rare situation, the court might find that the person's nationality and residence and right to private and family life is outweighing.
Excusez, c'est terminé, mais croyez-vous qu'on devrait...
Sorry. Do you think we should treat them separately, the UK citizen versus a foreign citizen, or should we apply the same rules to both?
Very quickly.
In my view, I think that there should be some factors where nationality and residence do have more weight. Private and family life, one, the right to be prosecuted in a particular country is another. So I do think there are some instances where there should be a factor to be taken into account.
Thank you, Monsieur Fortin. And last with Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I'm going to stay with Mr. Dubé again. In your opening presentation, you made reference to an obligation to disclose possibly exculpatory evidence. And I'm not sure how that actually operates, since you've also told us in the UK that generally no evidence is required for extradition requests. So could you simply come back to that point and explain the intersection there?
Of course. The obligation only exists if the prosecutor in the UK is aware of that information. And as you rightly say, in many cases they won't be, because the requesting state has to provide either evidence or a very limited amount of evidence. So the obligation can only arise if they are told something in the course of acting for the requesting state, which does undermine the evidence which they've already been given and put forward to the court.
Your last point in answer to my question, I think you're on to something very important for this committee to be considering, and that's the balance between the role of judges and the role of minister. And if I understood you correctly, really the role of minister has been reduced in UK to dealing with three things which are judged to be, I guess, more political, and most of the other legal decisions then moved back to the judge in the extradition proceedings. Is that correct?
That's entirely correct. So, I mean, they're political in the sense of specialty relations are country to country. So it's one country saying to the other, we will only prosecute for these things. The death penalty requires an assurance, a diplomatic assurance, if there's a risk. So one country saying to the UK, we won't impose the death penalty. And if there's been an earlier extradition request from another country, then it's the minister, competing international obligations. So that's right. Everything else has now been moved to the courts, and that's happened gradually over a period of time, but it's now completely clear that all of the rest of it is held by the court to deal with.
Is there any recourse to the courts after decision of the minister on those cases?
Yes, so in fact, a system where any appeal is heard after the minister has made a decision. So you have to wait for any appeal until the court has decided and the minister has decided. Once the minister has decided, then you can appeal again either or both of those decisions, but the appeal happens at the same time.
Much, Mr. Chair.
Thank you, Mr. Garrison. That concludes our first hour of this meeting, and I want to thank both witnesses for their very important testimony. So we will now suspend for a minute or two while we go in camera for the remainder part of the committee business. Thank you.
Thank you.